Matter of First United versus Town of Calicoon.
May it please the court. I'm Dan Vincelette. I represent the appellant, Town of Calicoon, and its assessor. There are two questions before this court on this appeal. One is a substantive issue.
Sorry, once again, sorry to interrupt you. Do you wish to save time for rebuttal?
Sorry. Yes, I would like to reserve 1 minute for rebuttal. Thank you. There are two questions before this court. One is a substantive issue, which is, was the trial court and the appellate division overly restrictive in their application of the burden of proof for real property tax exemption under Real Property Tax Law, Section 420A. The second question is more one of jurisprudence, which is, did the appellate division and the trial court improperly shift the burden of proof to the respondent town once the town raised an affirmative defense of zoning noncompliance by the petitioner?
Can you raise simply zoning noncompliance as an affirmative defense, or do you have to specify which zoning ordinance is allegedly being violated?
No, I believe it as an affirmative defense, and it was our sixth affirmative defense in our answer, was that the use of the property did not conform with the zoning code.
And then the burden goes back to them to prove a negative, like we've complied with every single zoning ordinance you have. Could be 500.
You could look at that as a negative, or you could look at it as a positive.
So that's what their burden is, though. Once you say you violated the zoning code, we don't have to tell you which zoning law, but you violated the zoning law, then that goes back to them, and they have to go through every law in your zoning code to say, no, we didn't, no, we didn't, no, we didn't, no, we didn't.
Well, Your Honor.
Why is that a good way to do business?
Well, Your Honor, this is the town of Calicoon. The issue.
But this isn't a rule for the town of Calicoon. So why is that a good way to do business? Why wouldn't a better rule be you raise an affirmative defense, you say you violated this provision of our zoning law?
Right.
And then they can say, no, we didn't, and have to come forward with proof that.
Right. Well, Your Honor, first as a matter of pleading, it was generally pleaded as to, there was a zoning,
somewhere in there, did you narrow these 500 zoning laws down to one?
Well, there weren't 500, Your Honor, but it was, it was the use of the property, and this was.
Isn't that generally zoning? Like use of the property, right?
Yes, it is. Yes. And the property is in the rural district, and there are only a few uses that are allowed in the rural district: single family, cemeteries, government buildings, stuff like that.
So, again, that may be true here, but in a case where there are 500 uses,
yes,
then it would be okay to just say you violated our zoning laws, and you have to say, I'm not using it for these, I'm using it for.
On the pleading level, yes. With an answer, it's no more overly broad than stating you failed to state a cause of action or there's no jurisdiction over the defendant.
It's an affirmative defense, right? They're saying we're a charitable institution, we're using this for appropriate purpose. You're saying all well and good, but even if that's true, you have to comply with the zoning law, and you have not done that. The question to me is then, what's the level of pleading you have to do to put them on notice of what you're alleging, right? Do you have to say you violated my zoning code, which may in another town be very extensive, or do you have to say, at least point to some provisions and say you're using it in violation of these?
It would be a better practice to state the specific provision or a schedule of the zoning code. In this case, I believe it was sufficiently pleaded, keeping up with the policy of liberal pleading, both petition and answer.
But given that it's vague, I'm sorry.
No, go ahead.
Monopolizing this.
No.
Given that it's a vague answer, right, or a vague raising of this affirmative defense, wouldn't there then be some obligation to clarify that in the course of a trial? Even if
Absolutely. Oh, yes, Your Honor, absolutely.
And I'm having a hard time finding in the record where you make the argument you're making to this court.
Well, we made a summary judgment motion. First off, we had an affidavit from the code enforcement officer with the zoning code attached to it, and he specifically stated, this use is not allowed in the RU rural district. He cited the provision of the code is 203-10. He cited that specifically and said any use that is not allowed in a district is specifically not allowed, and you have to apply for a permit or a conditional
And why
use.
is that not an implicit acknowledgement that it would be the town's burden to prove their affirmative defense? Because that's exactly what you did in that motion.
We raised it, yes. We raised it, Your Honor, and it was, On the motion for summary judgment, we raised that as an affirmative defense, and we held the burden on that.
And you introduced some support, some
Yes.
factual support for that allegation, thereby, one would think, making out a prima facie case for whatever relief
Yes.
you were looking. So to get to the second of your two questions, whether there was improper shifting of the burden, everything that happened on summary judgment would suggest to me that both the court and the town properly understood where the burden laid on the affirmative defense, which is the town has to prove it.
Well, the town did, the trial court held that the town did prove its prima facie case on summary judgment. It then shifts to the,
And is the rule, would the rule be different at trial? I mean,
no,
if
the rule is the same.
So you have to prove your affirmative defense at trial, right?
And we raised it. We did, Your Honor. And the thing with the shifting of the burden of proof is notwithstanding the burden of proof. The dissent brought this out in the appellate division. Even if the burden was upon the town, both the appellate division and the trial used an overly restrictive interpretation of the zoning code and the concept of the affirmative defense.
Can we slow down a little bit?
I'm sorry.
No, that's okay.
Yes.
If there were no tax issue here at all, somebody in the town has a piece of property and they're using it in violation of the code, according to the town brings a proceeding?
The code enforcement officer would probably cite
Right.
the
And
property.
then, right, and then in a proceeding, you agree that the town would have the burden there
Yes.
to show a violation of
Yes.
the code. So to Judge Garcia's point, you would then, in your affirmative action, right, this complaint you brought,
Right.
you would say, here's what they're violating, and it's our burden to prove that.
I believe there's a distinction, though, under the real property tax law. And there's two things. First of all, there's two proceedings here. In the first year, our firm was not retained until after the return date and issue had been joined. Under real property tax law, section 712, the town's not obligated to file an answer. All allegations within the petition are deemed denied, which would include affirmative defenses to be raised by a respondent at trial or in a summary judgment motion. In the second year, we made a motion to dismiss. It was denied, and at that point, an answer was served. But to Your Honor's point, with exemption, there's a policy in the state to have a restrictive interpretation of exemption, real property tax exemption. This court acknowledged that last year in the Brookline dialysis case. And this policy, it's, to Your Honor's point, there's a difference between public health and safety with code enforcement and the benefit of a real property tax exemption to foster charitable or religious works, or, you know, the flip side of that, which this court was concerned about in the Brookline dialysis case, was the further erosion of the tax base, particularly with rural communities, where, you know, the courts are taking an overly broad grant of the exemption to the taxpayer. So
But you would say that the other side needs some notice of what the provision is that they're allegedly violating, even in the exemption context, right?
I would agree, Your Honor, but at what point? I believe at the point of pleading with the answer, we had said there is a zoning issue here.
But let's say you had a trial here, and
Yep.
as I read that record, a fair reading of that record, the violation was the property was being used as a church or as an accessory use thereof. And all of the arguments, even where they touch on retreat, go to that violation. And now it seems, and maybe I'm wrong on this, that you're arguing retreat is not a separate viable approved use.
No, and I think that's the problem with the record, Your Honor, with the court's analysis, both the trial court and the appellate division. They tried to put the town into this church box, all right? At both in summary judgment with the code enforcement officer, we stated it's not a stated use under the rural district, all right? And not specifically
Agree,
the
and
church.
that's enough then.
Yes.
But you have to show something then.
Yes, and
it
then at
seems what
trial-
you were trying to show was
Right.
church or accessory use to it.
Right, and once again, at trial, and this went beyond the accessory or the church use, the assessor was on the stand, and she was asked, why did you deny this application? She said, because they stated they were a retreat or a
Right, so
prayer
she
house.
basically stated that she denied it on the papers that showed what their stated intent was when they purchased the property.
Correct.
But she didn't say anything about the actual use. Is that fair?
That's fair, Your Honor, but at that
So
point.
does that, Suppose I bought a piece of property in
Right.
Calicoon, and I hung a big
Yep.
sign up on it saying, this is a illegal fentanyl manufacturing plant.
Yes.
But I didn't actually put anything on there, and all I did is I let the neighbor mow and take the grass for his farm, which is sort of what happened here. Can you deny me, how do you treat that then? Is
Your
that-
Honor has brought up an important distinction between real property tax law, section 420A1 and A3.
Yeah.
A1 looks at actual use. At the time that this proceeding was commenced, the property was actually being used by petitioner, and it was admitted in the response to interrogatories in testimony that it was being used as a retreat center, a prayer house, or whatever else.
The testimony at trial, though, is not quite that, right?
Oh, the testimony at trial from petitioner was that the property had been purchased.
So let's slow down for 1 second again.
I'm sorry.
The only testimony about the actual use comes either from the petitioner, who says a men's group used it once for a retreat overnight, and there were 2 other times when people came there and stayed, I think, 1 night overnight, a youth group, maybe something like that. And that was, and that there was a plot that was being harvested, and they were collecting vegetables and distributing the vegetables to people back in Queens. And the only other bit of testimony, I think, in the record is from the town supervisor who lives next door, who said he didn't think that the plot was as big as they said it was, that was being used for the vegetables, and that he, for decades, and I think his family before that, harvested hay there and used it for their livestock.
Yes.
And that's all there was about actual use at the trial. Is that right?
I think petitioner's witness testified another times it was being used as a retreat center, and it
It
was
has been
being
used on like 3 occasions for an overnight stay by unspecified people. Do we even know in which tax year those occurred from the trial record?
I believe they were specifically asked in the interrogatories to define it by year, and I believe the testimony, he did testify when those groups came up to the retreat. The thing is, when is there a numerical requirement for actual use? If a retreat, if a group decides to use a retreat center once or twice a summer or whatever it is, that's an actual use. If they use it every day of the summer, that's an actual use.
So if they were actually harvesting the vegetables, as they said, and one night this guy and whoever else was helping him plant the seeds decided they were going to stay overnight and plant more the next day, that would be an actual use of, as a retreat, because they stayed over?
Yes. Yes. I think just showing up, churches or not-for-profits may have a retreat center that's generally not open to the public, but to members. They have retreats up there. Maybe it's a one-day retreat. Maybe it's just a day retreat. Maybe it's an overnight retreat. It's still a use of the property as a retreat house.
And was it the town's position at the hearing that a retreat is a prohibited use?
Yes.
As well as a
And
church?
Yes.
Where in the code is that made clear?
It's made clear, the RU district, there's a schedule of
Yeah.
uses, and one family, et cetera, et cetera. Then in that same section in the code, it states, any use that's not enumerated is excluded. And this is section 203-10 in the code. I believe that's on page 129, the code officer's affidavit. In paragraph 10, he refers to the fact that the code states if it's not enumerated, then it's prohibited, and you must go to the town board or to the planning
And the
board.
enumerated,
Sorry, go ahead.
Yes.
the enumerated uses are single-family home and farm, right?
No. There's a schedule of the code that states what the uses are, and they include, it is in the code officer's affidavit on R-129 of the record, and it's A through I, or whatever it is.
There's a lot of
There's about
permitted
A through
uses.
I or so,
Okay.
yeah.
I'm sorry, Jim.
But spiritual, church, accessory use, or whatever is not in there.
So just so I'm clear, is it your position that the use as a retreat is explicitly prohibited, or that, okay, and where exactly do we see an explicit prohibition? Your view is that they couldn't have gotten a permit for this use? if
Oh,
had
they could
applied?
have, but they didn't.
Okay, that's
they
my
didn't
question.
apply for it. Oh, sure.
Okay, so the problem is the lack of a permit
Absolutely.
request.
Yes.
But not that use as a retreat is categorically prohibited regardless. In other words, if you apply for a permit, you
Yes.
can't get
It's
it. You're not arguing that?
No,
Okay.
not at all. It's a permitted use or a conditional use. You would have to at
So
least
you
apply
needed
for
to
it.
apply for a permit?
Yes, Yes, and that's a
But
distinction.
absent the permit, you're in violation of the code.
I'm sorry, I missed the first part.
Absent the permit, you are in violation of the code.
That's correct.
And they were in violation of the code more than once.
Yes,
That's the testimony.
yes,
And
yes.
and that was the intent when buying the property to begin with. But the
Yes.
Chief Judge is correct. It's the use, the actual use.
That's
So
correct.
moving forward, let's say we agreed with you. That
Yeah.
there was a violation of the code and that ends the story. Moving forward, if they didn't hold these retreats, they of course could apply
Mm-hmm. Yes.
for
Oh,
an
sure.
exemption or apply for permission to hold the retreats?
Sure. Yes.
So they're not
abs-
foreclosed in the future from
No.
perhaps
No.
being exempt from taxation
No.
at some other point in
Well,
time?
this isn't, Your Honor is bringing up a zoning issue, and absolutely, there's
Yes.
no prohibition for them to apply for a permit for whatever use. But as far as exemption goes, and yes, if they had received a permit and they had their retreat there, then I would concede that there is case law and from this court that a spiritual retreat center or whatever qualifies for 420A.
But your position is if they are farming even a small plot of land there, as they say, as the record indicates they were, I think on both sides, and on one occasion during the tax year, they stayed overnight and continued farming the next day, that's in violation of the code.
Yes,
So a single non-conforming use is
Yes.
sufficient?
yes.
No, but you don't mean staying overnight is a violation. I understood your argument to be if the overnight stay is part of a retreat.
Well, even if you were there for an hour or two, even if it wasn't overnight, you're there for the purpose of a retreat. And
Well,
the
that's what
concern-
I'm saying.
Right.
That's what I'm saying.
Right.
It's not about staying
Staying
overnight.
overnight, no.
The point is the use itself.
Exactly, precisely, yes,
If the use is a retreat, that's in violation of the code.
yes.
So even if they're using a portion of the property for what is conceitedly a permitted use of the property, the other use of it, the retreat part of it, sort of invalidates their whole permission.
Yes, but, the town did take issue with the farming use, as far as.
Yeah, but
farming in and of
that
its-
as a factual question, was
Right.
resolved against the town at the hearing, right?
Right, but the farming use does not, it's the town's position, the farming use did not entitle the petitioner to the exemption. It's not even an incidental use. If you have a retreat, a spiritual retreat, a prayer house and spiritual retreat was the stated use of the property. Farming is not a part of that.
Didn't they have to show that it was exclusively used as farming?
Well, the statute says exclusive, and the court has interpreted it as primary. So the primary use of the property definitely was not for farm. It was for a retreat center. They had a barn that could.
Is that
yeah.
right? I thought the primary use measured in terms of volume activity was the town supervisor harvesting hay.
I'm sorry, Your Honor, I missed the first part. of your
Sure,
question.
isn't the primary actual use the harvesting of hay by the town supervisor who lives next door?
No, that really, it's just happenstance that the town
Isn't that-
supervisor lives next door.
Yeah, but isn't that most of what's going on the property?
I would submit that if there is, he was haying it because he's a dairy farmer and he's a crop
Yeah.
farmer across the road. That was for his own use or whatever, and that was by agreement of the previous owner and his family, and
But
now-
if we're looking at the actual use of what is going on there, there's some small amount of vegetables, you think, being farmed there, and a large amount of hay being taken, and a couple people coming on a couple of occasions for a retreat.
Right.
And so the primary use seems to me to be taking all this hay off the property, no?
Well, if that's the
Well, that's
primary.
not their use.
I'm sorry, Your-
It's supposed to be their use. That's not their use.
Right,
They may
exactly.
sell product, but
That's
that's
not a
not their
charitable,
use.
that does not come under the purview of the
It
statute.
doesn't further the church's goals.
It does not. The haying of the property by the
No, no,
neighbors.
go ahead.
Okay, the
Would
haying
that
of the
apply to
property.
would that apply to mining? So if you leased your land down and someone came on and mined it, and then you would say, well, that's not the primary use because I'm not doing it. I just leased my property to the guy next door and he's mining it.
Yeah, Your Honor, I am unaware of any case where mining would be considered an exempt activity under the real property tax law. I mean, I think that the real property tax law envisions there's just 5 groups that are entitled to this.
But hold on, I'm getting a little confused.
Okay.
We're not talking about their qualification for the exemption. We're talking about whether or not they're violating the code.
Correct.
And the question you heard from the chief was, there's some evidence in the record that the primary use of the property was I don't know if, taking hay is farming, but to me it sounds like farming.
Okay.
that would provide a basis for a finding that they weren't in violation of the zoning code. Nothing whatsoever to do with whether or not they qualify for a religious exemption.
For the farming use, you would be correct, Your Honor, but farming in and of itself is not an exempt use. It must be in furtherance of the purpose of the exempt organization.
Right,
This is a
but
church.
I'm talking about your affirmative defense that
Right.
they're not entitled to the exemption because they're in violation of the zoning code. And it seems to me like there's a quantum of evidence in this record that they weren't in violation of the zoning code, at least enough for a judge to reach that conclusion.
The haying that's been mentioned was not done by petitioner. It was done by a
Does that
third-
matter?
It does. Oh, it absolutely does.
Why, does that make it not a use of the property?
Not by the petitioner. The petitioner, there's two parts of the statute. One is it must be owned by a not-for-profit or religious corporation.
That's the exemption as opposed to
exemption.
the zoning code
Right.
violation you're asserting.
Right.
Those seem distinct, and so if there's evidence that the property is being used in a conforming manner, if we treat haying as farming, then where is there a zoning code violation?
The zoning code violation is the use of the property as a spiritual retreat center and as a prayer house. That's the violation.
Which is what he testified to,
Which is.
the retreat on more than
which
one
is-
occasion.
Which is what everyone, yes.
You have a red light. If I could
Oh.
just quickly ask this
Yes.
question, on the 2022 petition,
Yes.
did the town deny that on procedural grounds, the failure to request the exemption, or on
No.
the substance?
Yeah, no application was ever filed, so there was nothing to deny.
Well, was that the ground? Oh,
There was nothing to deny. So, agreements.
well, when you actually denied it,
No, there was no grievance, I'm sorry, there was no application to be denied in 2022.
I see.
So petitioner filed a grievance to the Board of Assessment Review. I believe he included the application from the previous year, and it was denied by the Board of Review, which, was then brought up for judicial review when the petition was filed.
okay, thank you.
May it please the court? I haven't been well. I'm Michael Altman. I represent the respondent in this case, the church in Flushing. When this initially
I
started...
just want to be clear, Mr. Kim did testify that there were retreats held on the property?
No.
He never testified that there were retreats held on the property?
No, there was no evidence of retreats.
That's not his testimony.
Whose testimony?
Mr. Kim.
No, he didn't. No retreats were held on the property.
Okay.
There was a service. They bought the property in 2018. A bunch of them came up and held some service there in celebration of the purchase of the property. And then on 2 occasions, groups of children came up to observe the farming, and they stayed overnight in what was titled, I think there was a sign there, Retreat House, but it was not used as a retreat, and there were never regular church services held there. I think this thing went south when the exemption was denied on 3 separate occasions, actually on 2. The first occasion was a year before. The assessor never gave the reason. When I filed the grievance in 2021, I think it was, I had no idea why the town hadn't given us the exemption the year before. I just put down, and you'll see if you look at it, I signed that grievance petition. I didn't know about that it was a zoning issue. I couldn't get the assessor to tell me why she denied. It looked like they were stonewalling us. So I put down, it was a church. Then come to find out, when they put in an answer to this certiorari proceeding, they were proceeding on some violation of zoning law, and it turns out we weren't violating the zoning law at all. There was never any proof in the trial of any violation of the zoning law. The place wasn't used as a a church. There were never regular services there. There was only that one service, or that one celebration, and it was never really used as a retreat. There were 3 separate occasions. The only evidence of use as a retreat was our own testimony, which was, excuse me, our own testimony, which was the judge found completely truthful. The assessor, whether she was playing us or she was just a novice, never told us and wouldn't tell me why she was denying this. And the supervisor who lived across the street wasn't paying for the hay. They were just allowing him to continue what he had been doing before. And his motive seemed to be he wanted them to get an agricultural exemption, which I assumed which would benefit him in some way. But we had a whole trial here. There was not one bit of evidence. Even the code enforcement officer didn't testify. And it was brought out that the assessor went to the property. I mean, this is a mandatory exemption. They didn't question the fact that this was a religious organization, a religious corporation, and that they were growing crops. And there was the only evidence about how about the crops was us.
When you say
we
mandatory exemption, they don't have to establish that they're using the property in conformance with zoning laws?
No,
Okay.
no.
Why not?
It's a religious corporation.
Wait, hold on. Why not? If you're seeking an exemption, you have to prove that you're entitled to it.
Yes, you
Here
do.
and
But-
here and here, based on the case law, in addition to establishing they're a church, which was the purpose, wouldn't they have to also establish that we're in conformance with all the zoning
No,
laws?
that is not something you have to establish.
Are you saying that because you're saying it's the town's burden to show that they're out of compliance?
It's a town burden to show that,
Suppose the town showed that they were out of compliance, would that then defeat their tax exemption?
purportedly, it seems to be the law now.
But you would first have to allege that you are in compliance with the zoning code, because if you're out of compliance, you're not entitled to the exemption.
No, and that's not true. We had to show that under 420A of the real property tax law, that we were a religious corporation, and we were performing on that property are what this corporation...
So if you are a religious corporation, you can use the property in any way you choose,
No.
even though it's not compliant with zoning laws?
No, that's not true at all. We were using it in conformance with what our mission was, which was
Okay,
to-
your
to-
mission, I get that, you're saying your mission, but you are insisting that the zoning laws don't apply.
No, I'm not saying that. But we don't have to initially show that we're in conformance with the zoning.
To get a religious exemption.
We had a religious exemption.
You're not entitled to the exemption if you're out of compliance with the zoning laws. You have to at least allege it.
Yeah, no, we don't have to allege that initially, and nobody has indicated. There's no case that says that has to be
So who
alleged, has to be shown initially. All we have to do is show that we own the religious corporation owns the property and is using it in performance of its mission. And that mission, as it turns out, was growing vegetables behind this building, which was already there.
I thought its mission was to be a retreat center. That, you could also grow the vegetables, yes, I acknowledge that.
Yeah,
but
well,
that-
they had
Mr.
some
Kim-
idea
Mr.
that they
Kim,
were going to
excuse
be a
me,
retreat center, but that
Sir,
was- it was
sir,
not-
sir,
I'm sorry.
Mr. Kim's statements were always that was intended to be a retreat center. Whether or not he held retreats, You've said he's never admitted to holding retreats, but that was the intent
Well-
for the purchase of the property.
That may have been part of the intent of the purchase of the property. But as the witness for the church indicated, what it turned out to be was a farming operation, not on a large scale, but they would do it on a regular basis and bring the vegetables down to Queens, and we had photographic evidence of this, and distribute among the poor people in the area of the church in Queens. And occasionally...
Let me ask you this. If there was a finding that there had been retreats held there, but there was also, as you say, the growing of vegetables, brought it down to Queens, all of that, would that then mean that your client was in compliance with the zoning code, even
I think-
even if partial conduct was in violation of the code?
It wasn't in violation.
No, I didn't ask that.
The town's allegation was that we were conducting services, and the retreat center was an extension of the church on the property. There was no church. It said retreat center was never used as a retreat center, and we had it for 3-4 years. Now they're gone. They were, the town didn't treat them right, and we didn't file this past year. But in any event, we had a whole trial on this.
Are you saying they no longer own the property?
They no longer own the property.
Okay.
They sold the property
Okay.
to a non-exempt group, so it's back on the tax roll as far as the town is concerned. But we had a whole trial on this, and there was not one bit of evidence presented that we were in violation of any zoning law. And that's the long and short of it. So I have nothing more to say.
Just briefly, if I may direct the court to R384.
To what?
I'm sorry, R384, Mr. Kim's redirect. Mr. Altman asked him about the groups that were up there, excuse me, and he stated that a men's group comes up as a group, women's group comes up as a group, elderly comes up. There was testimony that there was an elderly or senior Bible group that came up there. There was a youth group that came up there. There was testimony in the trial from Mr. Kim that there were retreats held up there. I'd also direct the court to R389 when I asked Mr. Kim, I'm sorry, R379, where I asked Mr. Kim, question, and Mr. Kim, the church did not purchase this property solely for farming services. Is that correct? Answer, no. Question, in fact, it was purchased for the purposes of Bible study, prayer meeting, annual retreat, and group meetings for the church. Is that correct? Yes.
Counsel, can you point anywhere in the record where there is an argument made by the town and use of this property as a retreat is not an approved use under the code?
Yes, in the summary judgment motion, there's the affidavit of the code enforcement officer, Kevin Ziers. He has the code attached to his affidavit, and he cites subsection 10, which states...
And he says in his affidavit, use of this property as a retreat is a violation of this code provision.
He states that it's not permitted under the RU schedule.
Use as a retreat?
I believe...
Or is it as an accessory to a church use?
I believe he states both. First, he goes to church accessory, and then he goes to subsection 10, which says any non-enumerated use is excluded and is only allowed with a permit.
Thank you.
Thank you. Thank you, Your Honor.